We don't actually have a lot of participants yet, Hella, so I think we'll just wait 1 minute for people to it might just take people a minute to come on. So hello, everybody who's joining us. We're just going to wait a minute for more people to join us.
It's so much nicer if we were able to see people in a room, you know, and see their faces. It's hard to look at a screen.
Yeah, and we do have a lot to get through, so I think we will get started now and people can join us in progress. So hello, everyone, and welcome. We're going to start with a land acknowledgement. We recognize that we are all joining from different locations today, and we will not be able to acknowledge all of the Indigenous lands our participants are living on. That being said, I would like to recognize that I am speaking from Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. Two of our panelists are joining from Ottawa, which is the unceded territory of the Anishinaabe Algonquin Nation. Two of our panelists are joining from Calgary, which is the traditional territories of the Blackfoot Confederacy, the Tsuut'ina, the Stoney Nakoda Nations, the Métis Nation Region 3, and all people who make their homes in the Treaty 7 region of Southern Alberta. All of us have a duty to reflect on the legacy of colonialism and to work for more justice for Indigenous peoples in our country today. In the spirit of reconciliation, we acknowledge this land and the Indigenous peoples who have lived on and taken care of this land since time immemorial. Hi, everybody. I'm Rosemary Oliver. I'm the fundraising director for Amnesty International in Canada. And I want to welcome you all to our very first interactive webinar on the basics of writing a will. This is a brand new thing for us, and so we're excited that you've joined us tonight. This webinar is being recorded for those who couldn't attend in person tonight, well, or on video tonight or on Zoom, and you'll be able to watch it again if you like. Before I introduce our panel of speakers, I want to ask all of you a quick question first. And it's a very simple question. Do you have a will? Yes or no? This poll should appear on your screen and you should be able to answer it. So I see even the panelists are answering it. So that's great. Well, it's actually, hosts and panels cannot vote. Okay, so we know. Good to know. This is the first time we've done it. So that's something new for us. And now I'm going to introduce our panel. We will come back to that, the results of that poll in a few minutes, but I want to introduce our panelists now. Our first panelist is Diem Nguyen, and she's been practicing law for the past 11 years. During this time, she has been fortunate to work with wonderful colleagues, students, and clients at various firms and educational institutions. She is delighted for the opportunity to share her experiences to help you with your planning and to answer your questions. And I just want to make a note that Diem is donating her time to Amnesty International, both in the preparation for this webinar and tonight and to answer follow-up questions. So we're very grateful to you for that, Diem.
Oh, it's my pleasure. Thank you, Rosemary.
Okay, well, thank you. Claire and Mark Stevens met while working for an advanced music school in the UK and have always shared a passion for trying to make a positive difference in the world. Claire is a collaborative pianist who fell in love with Canada many years ago and couldn't believe her good fortune when Mark won a job with the National Arts Centre Orchestra in Ottawa. They now make their home in Calgary, and they have been Amnesty International supporters for almost 20 years. Welcome, Claire and Mark. My colleague, Hala Almadi, has been a member of Amnesty International's fundraising team for 20 years. Today, she works to provide support and information to donors who may be interested in finding out more about how to leave a gift in their will to human rights work. A proud legacy donor herself, Hala takes great pleasure chatting with donors who are extremely passionate about human rights and many other issues that affect our world. As I mentioned earlier, I'm the fundraising director for Amnesty International, and it's been my privilege to work here in that role since 1999. I like to say I've been here since the last millennium. Raising funds for Amnesty International has been a huge privilege and a pleasure for me, and I'm always so inspired by our dedicated donors and the challenge that they present to us to try to work harder for justice and respect for all people in our world. I'd like to now go to the results of the poll. Do you have those, Nikib? Right, okay, so, well, it looks like we have the right audience for this session tonight because 40% of you do have a will and 60% of you don't. So for those of you that have a will, you might be looking for some tips on how to refresh it or update it. And for those of you like the other 60%, and full disclosure, I'm actually part of the 60% that doesn't have a will, which horrifies Hala every time she hears me say that. I'll be getting tips tonight that will help me in my estate planning as well. So thank you for filling that out. It's great to see who's here and your interest in this session. So we're going to start with Diem, our legal expert and our lawyer. And I want to ask you one question, Diem, before we go to the slides, if you want to go to your slides. Why is this topic so essential? Why is it so important for everyone to have a will?
There, I just learned to unmute again. That's an excellent question, Rosemary, because that's part of, those cold calls that I get at the office where someone will say, so-and-so told me I need to get a will, but really, why should I? And I'm fairly pragmatic about it. To be honest, if you don't have any loved ones, you don't have any close friends, and if you don't have any organizations that you value or support, sure, don't have a will. It doesn't matter. But luckily, most callers, and I think all of us, will have someone that we care about, friends, organizations that we'd like to support. And if you have a will, you can direct what you have acquired over your lifetime to those individuals or organizations that you care about. Because if you don't, it will not go to those individuals always. It might, but it won't always go the most efficient way as well. So again, if you're in that little 1% where there's no one that you care about, no organizations, then it's true, doesn't really matter. So that's the main reason, is to really allocate and making efficient use of what you've worked over your lifetime to give to those that you care about.
Thank you, Diem. Did you want to share the slides?
Sure.
A good time to do that?
I certainly can. Thank you.
Okay. Thank you.
And so what I can start off with, as Rosemary had mentioned, is I had a little slide here. And this, what I wanted to show you is some of the components of estate planning, because it's such a nebulous, very abstract phrase. At least that's how it sounded to me when I was starting out as a lawyer, was, I'd like to speak to a lawyer about estate planning. And I would always say, what a fancy term. Like, why don't you just say you need a will? Why don't you just say you need powers of attorney? And as I was, gaining experience, it finally dawned on me, estate planning is really an approach. And there are several components to it. So some of them will not apply to everyone, but typically when you're talking to your financial advisor, who really in my mind is the quarterback of the team. And that team, by the way, is usually the financial planner, the lawyer to help implement and provide some context, the accountant to advise on the tax implications, and more importantly, family members. Estate planning is great, but if your family doesn't understand it, or if they don't agree with it, sometimes I wonder what's the purpose, right? Because there's a cost to estate planning. And luckily, if you're in a position to spend money on estate planning, that's kind of a good thing. So that being said, you've got your team, and then some of the components within that are trust, family trust, wills, as we talked about. And in Ontario, I just wanted to point out, we have two types of wills. We've got the usual regular wills that everyone thinks about, and there are different variations of those regular wills. And then we also have this concept called dual wills. That's not in every province, but in Ontario, we do have that concept, and it's an ideal mechanism for certain situations. Then, as part of estate planning, we have what we call powers of attorney, which is about your estate while you are alive. So remember, wills at passing, powers of attorney while you're alive. So that's really important, that a lot of people might neglect to think about, because unfortunately, something can happen, whether it's illness, accident, that you're still alive, but you might not have the capacity to make these decisions about your assets as well as your personal care. So those are the two subcategories. Insurance is another possibility of part of the estate plan, again, depending on your life stage, etc. And then we have about registered accounts, which most Canadians are very familiar with. So RRSPs, and then if you're over 71, your RRIFs or RIFs, TFSAs, tax-free savings accounts, as well as RESPs. But that being said, RESPs, I added it there to remind myself to mention that they are treated very differently in Ontario wills than RIFs, RSPs, and TFSAs. And I just wanted to call that out because I think there's a myth out there that because RESPs are registered plans, how you treat them in estate planning is the same as RRSPs and TFSAs, and it's not. That's a very big myth, actually. And then the other idea of estate planning is also about how you co-own your assets. So in this slide, I just kind of picked the two most common ones where there's potentially co-ownership: bank accounts and real estate. And again, in Ontario, we have certain presumptions at law that is not common sense and is not obvious to the public. But for bank accounts, you can sort of deal with estate planning with your loved ones by adding them as a co-account owner. Depending on the relationship, Ontario law has certain presumptions that you have to sort of rebut if you don't agree with it. And when I say rebut, I just mean you write a little letter, you sign and you date it, and you say, I don't intend to do it this way, even though I have my adult child as a co-account owner. Or you might say the opposite. And the two main relationships we think about in Ontario are spouse relationships and adult children and adult parents. So we see that a lot. That's something to sort of be aware of when you're co-owning. And it's estate planning because when you have more than one account owner for bank accounts, when one individual passes away, you don't need to worry about probate. You don't need to really deal with the will. There are exceptions, of course, but that's the concept of why I think of co-owning assets as part of your estate planning. Then for real estate in Ontario, again, and I think it's common in a lot of the other provinces, but not all of them, is we have two ways to co-own real estate, and that affects your estate planning. So first of all, do you own it by yourself or do you own it with someone else? That will affect estate planning. And then if you own it with someone else, we've got where you can own it together, where there's a right of survivorship, meaning that if one owner passes away, the other one, by the right of surviving, receives that property because they're joint tenants by the right of survivorship. So therefore, it doesn't matter what the will says, even if the will was specific about that particular real estate. Because again, in Ontario, we have this sort of legal fiction about joint tenants when you own with the right of survivorship for real estate. What happens is when title is taken as such, we kind of pretend that 1 second before the last breath, it goes to that surviving co-owner. And that's why the will never really steps in, despite perhaps mentioning the real estate. Then we have the other co-ownership where it doesn't matter what percentage you own, but on the passing of that owner, their percentage of ownership interest will go in accordance with the will. So you can see there are different circumstances where one or the other might be preferable over the other one. So I wanted to just give a quick overview of when we talk about estate planning, what could it mean? There definitely are other components to it, but these are the more common ones. And so, for example, when we talk about gifting to an organization that you care about, a couple of spots that are pretty common are possibly registered accounts, where we talk about designating the organization as a beneficiary. That's one possibility. The other possibility is insurance. So in life insurance, you might want to designate, again, the organization as a beneficiary or a backup to your spouse. And then also conceptually thinking about powers of attorney, because powers of attorney are documents that gives someone else the authority to make decisions for you. So therefore, that person that you've given that authority to has a fiduciary duty to you. They're only supposed to use your money for your benefit. So as much as it sounds logical that if you've been donating to Amnesty all these years, then you had an incapacity situation, your attorney can have a little bit of an issue taking money from your estate and donating it to an organization, because it's not really in the best interest of you as the individual in this strictly pure context of fiduciary duty. So in powers of attorney, one way to deal with that is we have a clause in the power of attorney for property that we say, look, if I normally donate to an organization, and there's sort of a historical examples of it, as long as I can still afford to do it, you are permitted to keep on doing that for me. And that's not seen as a breach of fiduciary duty. So I think about powers of attorney and the idea of donating. That's where we have that clause to just give that other person that sense of comfort of feeling like they're not doing anything wrong, and that no one's going to sort of point a finger at them and say, well, why did you start giving money to charity when X, Y, Z? It sort of parallels to like giving gifts to your grandchildren, actually. That's not you. Someone's taking money from your bank account to give to a third party. So having that clause just makes it easier for someone who's trying to help you during a difficult situation. And then the very common one is wills. That's the other component where, again, you can donate to an organization inside, whether it's regular wills or dual wills. And there are many ways to do it within the will. And some of the questions were given to me in advance, and I'm ready to answer those whenever you would like me to, Rosemary.
Okay, great. Thank you, Diem. Well, let's, so you have talked, one of my questions was going to be about the difference between an estate and a will, and it feels like you've talked about that a bit. And another question I'd like to ask is, if you're single and don't have any property or any children, it's kind of the scenario that you talked about at the start, do you still need to have a will?
I think, first of all, you have to familiarize yourself with what would happen if you don't have a will, and then decide, are you okay with that? So for example, in Ontario, if you do not have a will, there is a set of laws that will say, you know, do you have a spouse? Because if you have a legally married spouse, they're entitled to a certain portion first, after all the expenses are paid, and then they get a certain portion. So right now it's $350,000. And then after that is subtracted, whatever is left, do you have children? Because if you don't have children, then the balance of whatever is left goes to that legally married spouse, not common law spouse. Then if you do have children, it depends on how many children you have. So if you only have one child, then whatever's left after the deduction of $350,000, half of it goes to the legally married spouse and the other half to the child. But if you have more than one child, then a third of what's left goes to the legally married spouse, 2/3 is divided evenly amongst the other children. Okay. Now, that's really not an issue typically when, if you were, say, married, first marriage, the kids belong to both of you. Where this scenario, and you have to understand, it was done during a time where it was like, you know, legally married was the common situation, not common law in Ontario. Like, it sort of reflects historical life scenarios, if I would say, right? So it doesn't always respect the wishes of a lot of couples who are just as equally committed, but are common law. You can see how if someone had children from another union, and they were deeply committed to their current common law spouse, and they were together for 30 years, how that common law spouse might not actually receive anything by law. And so that doesn't quite point to the question that you had asked about single. So as a single person, I'd say, what would happen if you don't have a will? And are you okay with that? So as a single person, you would not have the spouse. You did not have children. Then it would go to your parents, whoever survives you. And if you had no surviving parents, then it's divided evenly amongst your siblings. And if you had a sibling who died before you and had children, that sibling's share would go to their children. That's okay if that's what you were happy with in the first place. So sometimes I think about what would happen if you don't have a will. Now, the challenge is if any of those individuals that you were okay with is a minor at the time of your passing, so I'm thinking usually the nieces or the nephews, their share doesn't go directly to them. Their share gets deposited to the Ontario court, the accountant of the Superior Ontario Court, and it gets held in trust by the court until that niece or nephew turns 18. If you don't care, that's okay as well. But if you do care to try to pull money out, then what happens is that parent of that niece or nephew needs to apply for guardianship of property, so a court application, in order to pull the money out. So that's a use of money that most people, I think, would agree, why would you want to spend your money there if you didn't have to? And secondly, there's this whole issue about sort of access to justice. If the money that's going to court is only $10,000, which is still a lot of money, but if that's the amount and you think about the cost of doing a court application with a lawyer, proportionally, it's such a large component. When had that money been $1 million deposited into court, then sure, the proportionality is different, right? So because there was one question where I don't have very much, or I'm at a stage where I had maybe a neutral net worth. Part of it is just the fact is proportionally the cost to get things done will eat up whatever you do have. And in a way, I feel more strongly about people with less money to do the wills so that we reduce costs in the long run. I also believe it's important for people with lots of money, because then at least there's there's sort of tax strategies. There's different things we can do with the different components of estate planning to minimize the tax and maximize the gifts. So that's where I land with that question.
That's great. That's a great answer. Thank you. Diem, I'm wondering if you can stop sharing so we can get some of the other speakers a bit bigger on the screen. And I'm going to ask Hala a couple of quick questions, and then we'll get to Mark and Claire. Hala, what is your role at Amnesty International?
Well, I guess in the simplest of terms, I am the liaison between Amnesty and our supporters or the public, anyone who has questions about how they can leave a lasting gift to human rights through Amnesty International. I get a lot of inquiries from donors, usually in their exploratory stage. And I mean by exploring their estate at large, not just their gift to the organization. And they're wondering about what kinds of gifts, what ways there are to give to Amnesty beyond their lifetime. They're wondering about what kinds of gifts we can and cannot accept for whatever reason. And I just wanted to add here that you don't have to be committing yourself to a gift if you start a conversation with us. I mean, I work with my lovely colleague, Jessica, and together we are basically the connection to the organization for anyone who wants to start the conversation. We really welcome that conversation. And I wanted to say that, speaking of, do you have a will or not? I mean, my own personal journey towards getting our will done and getting it signed took a few years, and that's my husband's fault, I have to say. But to throw him under the bus. But, you know, that enabled me to really understand the process of what it means to really sit down and make those sometimes complex decisions around, you know, your loved ones and the causes that you love and what you'd like to leave for the world. And so I've been in those shoes, and it really informs my work at Amnesty with our donors. And I hope that people will leave tonight with two messages, mainly that, yes, it is definitely important to have a will and to make your declaration on how you want your life earnings, whatever they are, to be spent. But number two, your will can also be more than just a legal document. It can be a powerful tool for positive change in the world. And for me, personally, I think our will is kind of like a love letter to our family and the planet we're leaving behind. You know, that's why the one thing that made me excited about getting our will done was leaving money to charity. And I'm really proud to be a legacy donor to Amnesty. It's something that gives me a lot of hope. And it's really an act of love to leave your statement for your loved ones, give them peace of mind to know that they're doing exactly what you wanted them to do with your estate.
That's great. Thank you, Hala. I want to turn to Mark and Claire Stevens, joining us from Calgary, as we said. And thank you very much, not only for joining us tonight, Mark and Claire, but also for your support over the past 20 years. I was wondering if you would mind sharing with the audience tonight what led you to make the decision you made to include Amnesty International in your will.
Who goes first? Well,
it's probably quite a long story. So as you can tell by our accents, we're originally from the UK, and we first made our wills when we bought our first flat in London, and we had something then to worry about once we had died. We don't have children, and we were thinking we want to make sure that it's as simple as possible should something happen to both of us in quick succession. Back then, for me personally, I grew up with very religious parents, and one of the few vestiges that have made it through to my adulthood is my life philosophy, which I would describe as, I think you call the golden rule here in North America, which is do as you would be done by. And I became aware as a teenager of the inequalities in the world. I became vegan at 18 and became more aware of human rights as well shortly after that. To cut a long story short, Claire and I met in our 20s. We got married a few years later, and we were having a discussion around our values, what we believed in. I think I was reading a Peter Singer book about giving to charity at that time, and he was very clear that everybody should be tithing, and if we all did tithe a certain amount of charity, the world would be an extremely different and much better place. And I think that got us started on the conversation about who we were donating to at that time. And at that time, we decided we would focus on three main charities, being Amnesty International, Oxfam, and the Vegan Society in the UK. We moved to Canada 7.5 years ago now, and obviously a big life change, living in Ottawa for most of that time. We've only recently moved to Calgary, and we were again getting ourselves settled first of all, but then going, okay, how are we going to be supporting what you said, Hala, there about really you echo certainly how we feel, I think, and certainly Claire, all credit to her, got onto this, and again making wills in Canada for property that we have here now, and thinking about who we want to support, what legacy we want to leave, not having kids, and who that goes to within our family and loved ones, and the organizations that we strongly believe are making a massive difference to the world, like Amnesty. What would you add to that?
It's covered it pretty well there, I'd say. I mean, it's an organization that's so close to our hearts, and it seems just kind of a no-brainer really to me that it would be included in any estate planning that we're doing, so that that support that we want to give to Amnesty continues beyond us. Because I mean, as we know, the world is a crazy place, and there are situations that are just not getting better. So Amnesty is more vital than ever, and I'm happy to be a part of supporting that.
And I would say just that basic idea of it is better to light a candle in the darkness than to curse the darkness. Really, do something. Even if you think you're one person holding back the tide, do something. And I think Amnesty does that extremely well. And I don't know that Amnesty would even know that we had left things into you in our will had we not reached out to just check that we had the wording correct, to make sure it really did go to you and we weren't going to stuff it up. So it was through no pressure from Amnesty that we were doing this.
Well, that's great. Thank you. One of my later questions was going to be, why did you decide to share the information with us? And so it's interesting that you did it in order to check and make sure you had the name and details correct. Thank you, Mark and Claire. We're going to go back to Diem for some more legal issues. But before we do that, we have a couple of polls that we want to ask everyone on this call. Does marriage revoke a will? Is going to be the first poll question. And we want you to answer that yes or no. And when you've all finished answering that one, then the next question is going to be, does divorce automatically revoke a will? And then we're going to get the answer from our legal expert. So I see we're still on marriage. So if everyone can fill that in. Okay. So 29% believe that marriage does revoke a will and 71% believe it does not. And then let's do the one on divorce at the same time. The other end of the spectrum from marriage. So does divorce automatically revoke a will? Yes or no? Okay. Hopefully everyone's filling that in and we can see the result. 27% believe it does and 73% believe it doesn't. So now we're going to turn to Diem, our legal expert, and she will tell us the truth about both of these areas. Thank you, Diem.
There we go. My pleasure. So I was very excited when I saw those two polls, Rosemary. I don't know if you came up with the questions or someone else did. And the reason why is we're going to start with the divorce question because that was the easier poll. And actually, a divorce does not revoke a will. Okay. What it does do, though, is it revokes any appointments to that former spouse and any gifts to that former spouse. Unless there is a clause that says, despite the divorce, I still want to give it to that former spouse. Then you can override the law there. If I recall, to try to sound a little bit fancy, I think it's Section 17 of the Succession Law Reform Act in Ontario, but don't quote me on it. So, and that's a common myth, is that when you get a divorce, you know, the whole will is invalidated. So when I'm talking to clients about a legal divorce, not separation, legal divorce, sometimes you don't need to change your will urgently. It's nice to clean it up, obviously, but a lot of times if it's the first marriage and the will is what I expect to see it, everything to my spouse is the appointed executor, the backup executor is my sibling, the backup beneficiaries are any children we have in equal shares, then I would say, you know what, there's a lot on your plate. Don't worry about it now. Let's deal with doing a new will a little bit later once you've got sort of the bandwidth for it. And that's the reason why. For marriage, the answer is neither yes or no. The answer is actually, it depends. So it depends, when did the marriage happen? Because prior to January 1st, 2022, yes, marriage automatically revokes a will. However, if you had prepared, if you've done your will and you are married after January 1st, 2022, it does not necessarily revoke the will. Prior to 2022, January 1, there were a few exceptions to marriage revoking the will as well. If you had what we call the contemplation clause, where you said, I'm writing this will in contemplation of my marriage to the name, that's a valid contemplation clause. But if you just had a clause where it said, I'm writing this will in contemplation of a marriage one day, that would not cut it. The exception is not there. It had to be to a specific individual. So therefore, if you've prepared a will and then got married before January 1st, 2022, you should talk to a lawyer. And again, this is all in context of Ontario. And then if you were married after January 1st, 2022, have a look at your will just to kind of refresh your memory to say, even though I got married, my will's not revoked, does it still reflect my wishes? Because it might, because perhaps you were common law or you were in a long-term relationship and decided to get married, but had always contemplated your spouse in that will. So maybe you don't need to change anything. Or maybe you do because the will was from, 15 years ago and you didn't know the person at the time.
Okay, thank you very much, Diem. That's very helpful. We're going to move to taxes for a moment for a couple of questions on taxes, and then we'll get back to Hala and Mark and Claire. So one of our participants has asked, what are the main tax implications of leaving a gift to charity in my will? And I'm going to do the follow-up question at the same time because you may be able to answer it at the same time. Is it better for me to name a specific amount of a gift to a charity or to leave a percentage? Okay.
So again, disclaimers is that I do not know tax law and I'm not a tax accountant, but I can answer very generally to kind of get people thinking. So first of all, you have to ask, what type of tax are you worried about? Because when you pass away, there are two types of taxes I'm thinking of in Ontario. It's not quite the same, I believe, in Alberta, because I think in Alberta, I'm only just guessing, but I don't think they have what is equivalent to estate administration tax at the provincial level. I think for probate in Alberta, it was like a flat fee of an application. But in Ontario, on passing, if probate is required, which is not always the case, but if it is required, then the province levies an estate administration tax. It's approximately 1.5% of whatever passes through the will. So not your insurance proceeds if it goes to a person who's alive. It is your insurance proceeds if it goes to the estate, because now it flows through the estate and then it gets distributed in accordance with the will. So there's certain assets that will get covered by that tax. So that's the provincial level tax. Then the other type of tax I think most of us think about is what is being regulated by Canada Revenue Agency. So either deemed capital gains or any income tax arising from the income of the assets after death. So let's say you have a bank account, there was $2 million in there and it was generating interest. There would be taxes on the income generated on that portion. So that being said, no one, quote unquote, gets taxed on the inheritance or a gift to any organization. What happens is upon passing, whatever applicable taxes are applicable, I guess. And also there's also what we call land transfer tax as well. So there's lots of different taxes depending on your assets. Real estate would be one of the large ones. All of that gets paid, quote unquote, by the estate. So once a gift actually goes out to the beneficiary, individual or organization, it's sort of after taxes and debts have been paid. So as a person who's receiving it, do you get taxed on your inheritance? No. Do you get taxed on the gift? No. But income arising from that the moment after you receive it, yes, because it's income tax now. And I would imagine it's the same for organizations such as Amnesty or any of the wonderful groups out there where when they receive a bequest, they don't, quote unquote, get taxed on it. But then once it's in their bank account and if there's any interest being generated, then they get taxed on the income of the gift. And then I think your follow-up question was, should we name a specific amount or not? I always say it depends on how much are you thinking about leaving. Because in Ontario, the way it sort of works is that specific gifts take priority over what we call residual gifts. So the first priority upon passing is debts and taxes. That gets paid off. Then whatever's left is the next grouping is specific gifts. So if we're talking about, 10,000 here, 10,000 there, 100,000, whatever that specific amount or gift is, that gets paid out first. Then we have the residual clause where then you name whatever's left, please divide it amongst my children evenly, as an example, or please divide amongst X, Y, Z evenly, or by shares, percentages, it doesn't matter. So if you have a lot of money proportionally left, then these people at the bottom will get a larger bulk. But if you don't have a lot proportionally between the specific gifts, all of those, and the residual, then you're kind of favoring the folks with the specific gifts. And that's okay if that is your intention. So when you're sort of thinking about how much you want to give, you want to think about how proportional is that specific gift in relation to my wealth that's going through the will. And am I okay with the consequences? Because a lot of times people might say, I'd like to give X dollars to Amnesty, which is great. And then whatever's left, please divide it amongst my 3 children. Well, unfortunately, if your 3 children don't have very much, and if your gift is, let's say, 100,000, and at your death you have 120,000, then as long as you can understand, 100,000 will go to Amnesty, which is great, but is that the intended consequences that the 20,000 will be divided amongst the 3 kids? And you can imagine maybe a bit of disappointment if it was not discussed in advance. And again, this is just one part of the estate planning, because perhaps there's that insurance policy of $5 million that are going to the children. And that's why we did what we did in the will, right? So it's the big picture that I think will dictate, do you do a specific amount, and how it relates to your overall wealth. And is the consequence, if you lost money over the years, will that be okay versus, you still have what you think you have at death? The other way to sort of address that conundrum is to do it by, percentages of the residue. So instead of naming specific gifts, you could say, let me do 10% of whatever is left to X, and then percentages to Y and Z, etc. And that way it's always proportional, which is perhaps maybe an easier way when you're thinking about larger legacy gifts, so that you're thinking about your loved ones as well as supporting the values that you want to live on after you.
Okay, thank you, Diem. I'm just going to ask you one more question because you mentioned the word probate, and that was going to be a later question for me. So if you can just quickly describe for us what probate is, and then I'm going to pass over to Hala and then Mark and Claire again.
Great. Okay, sure. So probate is simply a court process that says, yes, that person who was picked as the executor has the authority to still speak for the estate. And yes, that will is the last and final will of the deceased. Probate can happen whether you have a will or not have a will, because if you don't have a will, the odds are higher that probate will be required. And instead of quote unquote stamping the will, what the court will say is, here's a certificate to just say this person has the legal authority to speak on behalf of the estate. Because if you think about it, probate is simply a process so that the rest of the world knows who should they be speaking to, because the person that normally owns those assets has passed away. And we don't know the relationship between the deceased and their current spouse. We don't know if there's estranged relations between the deceased and his or her child. We just don't know any of that. And I think it's sort of a reflection of, not knowing the individual well. And it's common nowadays, right? If most people don't even go to the bank. So the branch manager wouldn't know who really, or the relationship between the deceased, and someone shows up with this piece of paper that says, they're the executor. So that's really the reason why we have probate. And what it is it's simply a court approval of a document, if it exists, and if not, issuing a certificate so that we know who can we talk to without fear of liability.
Great, thanks very much. We're going to talk a bit about changing your plans. So once you've made a will, people sometimes change their wills. Hala, I'm wondering how often people get in touch with you to update their plans or to make changes.
Yeah, I mean, it does happen. I mean, my experience, I tend to deal much more with the sort of start of the process for someone. And my colleague Jessica tends to deal more with the people who have already confirmed a gift in their will and are maybe changing their plans. It does happen, not frequently, but, we have to understand that like people, wills are kind of changing with time, and they need to be revised because our circumstances change and our lives change and things move on, and we move and we buy more things, so it does happen for sure. And it's important to always be there for the donor to make sure that their concerns and questions are answered.
Thank you, Hala. And I want to turn to Mark and Claire and ask, how many times would you say your circumstances or goals have shifted and that you've updated your plans? And do you continue to update your will, and what motivates these updates? And then we're going to ask the audience a poll question about whether they do this themselves too, but we'd like to hear from Mark and Claire first.
I'd say every time our circumstance changes, we would look at updating a will. Like, for example, when we moved to Canada and acquired assets here, then we revisited what we had and whether we still agreed with the allocations that we'd made and that kind of thing. But it's only for really major life events, I think, that it would happen.
I think for me, it starts on a legal basis of, are our wills that we've already written valid where we now moved to? So moving from the UK to Canada was a big one. And of course, now what you're saying about the differences between Ontario and Alberta, we will be revisiting this if we acquire assets in Alberta, and make sure that we are covered and that things are as easy as possible for people picking up any pieces should we, die together at some point. And that's the sort of first thing. But then, as Claire says, you then have an opportunity to revisit what's in there, and we sort of check all of our different wills and hope that because we do still have a will in the UK as well, I think, for things there, and then the Canadian will. As Claire says, the big life changes trigger that more than anything else. It's not, you're not just scratching your head one day thinking, gosh, I think I'll check my will out.
Okay, terrific. Thanks very much for that answer. We have one last poll tonight, and it's on this topic of, if you have a will, are you updating it on a regular basis? So please answer that yes or no, just so we get a sense of the audience and the people that are here participating tonight. And then we'll be going back to Diem with some more technical questions, legal questions. And the first one, Diem, so you can queue up your answer, is, are online wills valid in Ontario?
I think it depends on what people refer to as online wills, right? If they mean those are great results.
Good. Yeah, fantastic. Okay, back to you again, Diem.
So if the person who was asking the question thought of sort of like a website where you enter your data into it, it asks you various questions, and then you press generate, and then you print it out, and then you sign it with a pen with witnesses around you, then yes, it is valid, because in Ontario, we have a few formal requirements. One of them is that it has to be written. So if someone had thought an online will as, say, a video, at this point, no, not in Ontario. I thought I read somewhere there was more of a direction towards that as an option in British Columbia, possibly. I could be wrong, but that was something there. But from Ontario, the purely formalities that are required is written. There is an age requirement of being 18 or older, unless you are married, so you can be under 18, and unless you are on active duty. That's also another exception to the age requirement. And so the other requirement I mentioned is about witnessing. You need to have 2 witnesses. That's if it's printed out. Now, if you wholly handwrite in your own handwriting, or if you can't handwrite, but direct someone to do it on your behalf and you're there directing them, then you don't need witnesses. And that's what we call a holographic will. So holographic wills are valid wills, but the nature of them is wholly handwriting. And the challenge with that is, again, if you think about it, after death, you have this person that walks up to the bank or wherever assets are stored, the land registry office, the bank, etc., and holds this piece of written paper and says, I'm the executor and I'm also the beneficiary. You can understand how bells might go off. So typically with holographic wills, most banks, almost everybody will require probate, more likely because we're all afraid of liability. At least with witnesses, it's a little bit better. But when there are witnesses, people need to remember that if you do it from the computer, where you generate and then you get this document, you need to have what we call an affidavit of execution. Basically, a witness will go in front of a commissioner or a lawyer who is a commissioner or a notary public, and they will say, yes, I looked at the witness's ID, and yes, they were over 18, and yes, they were one of the witnesses to that will. So there's that extra document that a lot of non-lawyered prepared wills might miss. And it can be done later. But again, depending on if you picked your 2 neighbors as your witnesses and you've moved or they've moved, it's just more difficult. So always valid and legal, but it's more about how do we keep it as simple as possible to honor your wishes. And truly, I've done probate for wills that are holographic. I've done probate for wills that are computer generated from websites. And I've also actually done probate for wills from the UK and from Quebec. And it just depends on what's going on. So all I can say is that when you have a lawyer do it, just the odds of being asked to probate are less. That's the only thing. It doesn't mean it's perfectly no probate required. That's not the case either. The one thing that Mark had mentioned, and I just want to slightly jump in on Mark and Claire's comment about having a will in the UK, is that just FYI, have a look at your will in Ontario, because you can have more than one will, around the world, because sometimes it's simpler to have a will in the jurisdiction that's holding the asset. The people over there are more familiar with how it looks. They know the formal requirements. But if you're going to have more than one will in coexistence, you just always want to have a look at your revocation clause. So your revocation clause in your Canadian will needs to exclude revoking the UK will as just something that crosses my mind. And it sounds like yes, so that's great. But that being said, with wills, in my slide earlier, I had mentioned you can have what we call dual wills. The concept of dual wills is really having more than one will. You could have 3 wills, 10 wills, whatever. It just doesn't happen frequently. But you do have multiple wills to either make probating simpler and quicker in the relevant jurisdiction, or you have more than one will in Ontario to minimize your estate administration tax.
Okay, thank you, Diem. I want to turn to Mark and Claire again and ask, we're very grateful for you being here tonight and sharing your story, but we wanted to ask why you decided to share your story with everyone tonight. And also, if you could, if there's anything else that you want to say tonight, because we've got 9 minutes left. So I'm going to just say, this is your chance to not only tell us why you joined us tonight, for which we're grateful, but also anything else that you'd like to say tonight. Please go ahead.
Well, I mean, simply Hala asked us, and we're always happy to do anything that supports the effort to encourage more people to support Amnesty. Yeah, so really just say, there's nothing special about us really, just that we care and we wanted to ensure that had something solid to leave behind. So.
And I would just say in front of everybody, thank you all and Amnesty and the staff and volunteers like Diem for all that you're doing for human rights around the world. And to everyone watching the call, it gives me a great deal of hope that we're all in this together and we believe in this and we're supporting Amnesty to make a difference.
Thank you very much, Mark and Claire. That's wonderful. I want to turn to Hala the last time, because we also have some more legal questions for Diem to come to, which we'll try to squeeze in the last few minutes. But Hala, I'm going to 2 questions. One is, what is the checklist that donors need as they're deciding to leave a gift in some way? And I also had a new question come from the audience that said, how important is it to get the legal name correct for the charity in your will?
Well,
so
absolutely.
both of those.
I'll start with the second question. Yes, it is very important. You'd be surprised sometimes at how many different variations there are of the organization's name, and it can, in some cases, put into question which entity is the recipient, especially when there are different groups that have charitable status that are connected to Amnesty. So that's a really big question, but it is really important. The checklist is, it can vary from one donor to the other depending on their individual needs, especially if they have questions about the mission and the mandate in addition to their needs to address their desire to leave a gift in their will. But our information brochure essentially holds all the information that they need. Besides having snapshots of human rights impact stories and testimonials from other legacy donors, it has essentially our legal name, the address, the charitable registration number, sample wording for the will. And this is a part of the toolkit they need to take to the lawyer's office. And make sure that they have the accurate information there to help them finish off their will and not have any doubt about who they're leaving it to. So I think that's it in terms of checklist. Yeah.
Okay, thank you, Hala.
Sure.
Diem, we have an interesting question. How is your lawyer informed of your death if you have no family members around?
That's a really good question. Truly, no one informs us. And it only matters if your loved ones need the will and if that lawyer is holding the original will. So not all lawyers hold on to the original wills. Sometimes clients will take it with them after documents are signed. So therefore the lawyer doesn't really need to know about the passing because the original will is with the loved ones, hopefully. But the more important thing is if you have a will, you should be telling your loved ones where to find it. because whether you're holding the original yourself or whether you have a copy of it, usually if you look at the names of the witnesses, if the lawyer did it, the lawyer is going to be one of the witnesses. So your loved one will be able to find the lawyer to retrieve the original if they still have it. And it's actually very interesting about who has the original if it cannot be found. So the implication is that if the lawyer is holding the original, or that's where we all sort of agree it would have been, but it cannot be found, then there's a process to deal with that. If the original went home with the client and it cannot be found, then we work with the presumption that actually the client destroyed the will. And you have to have evidence to show, because you might have a photocopy or scanned copy, but now there's this other process to show that we can't find the original and it's clear that it went home with the client. So how do we rebut the presumption that it was destroyed? So you have to like spend a little bit extra time to deal with that. So it's actually a really good question about where should it be stored. And that's why as lawyers, we actually don't know if someone passes away. And from a professional obligation is, I am to hold any of the wills that I actually do hold until I'm informed the person has passed away. I cannot assume they passed away at 99. There's no, after maybe 150, but I won't even be around. So, but it's that sense of obligation to hold on to it.
Okay, thank you. And I think we have time for one last question. One of the participants says they wrote a quick will a few years ago. Their circumstances have changed and they want to make different provisions. They want to make sure that earlier will is null and void. How can they ensure previous wills are no longer effective?
Well, there's two ways. There's what we call by law and by the testator. So by the testator, I mean the individual who wrote the will. What they can do is intentionally destroy it, right? And then just try to get rid of all the copies so that no one's following another process. But you intentionally destroy it. And to make sure it's properly destroyed is that you cannot be drunk. And you need to have capacity when you are doing this to your document and shredding it. So that's one way. Then destroy all your copies. Then the other way is by law, where if you do another written piece of paper while having capacity to say, I revoke all prior testamentary documents I've prepared, et cetera, by law, that is revoking that other piece of paper that still potentially exists in physical form.
Okay, that's wonderful. Thank you, Diem. Is there anything else? We've got 3 minutes left and we promised everyone we would wrap up on time. So I just wonder if there's anything else you want to say, Diem, before we end the webinar.
Nothing legal, just a big thank you to Hala for inviting me to do this, because one of the things I struggle with is how do I help as this one individual in the world, and just being able to do this part of it is such a great opportunity for me to feel like I'm actually doing something a little bit, right? And I feel very inspired by Mark and Claire's story about how to sort of keep it going on and not feeling overwhelmed by everything that's going on in the world. And but yet if each one of us just takes a little action, hopefully there's that ripple effect. So thank you, Hala, for giving me that opportunity to do this.
My pleasure. Thank you.
Okay, and I want to formally thank all of our participants and our panelists tonight. And Diem, you asked earlier who asked the poll questions. That was Hala. So Hala did most of the organizing for this event, and it's our very first one of its kind. So I think, from our perspective, it's been really exciting. And I want to take a moment to thank our legal expert, Diem Nguyen, for donating her time and for sharing her expertise about this important topic. Claire and Mark, I want to thank you so much for participating from Calgary. I know it was in the middle of your afternoon, or sort of late afternoon, and also for the amazing decision you've made to include Amnesty International's human rights work in your will. We're really grateful for that. A special thank you to Hala for having the idea to organize this event and for doing all the work to get it going. And Hala will also be sending out the link to the recording in case you want to watch it again. There are some questions we might not have been able to answer fully, and we will try to follow up. If we have your name, we'll try to follow up with you individually to get that information to you. I also want to thank Nakib Sarwari, who was doing the behind the scenes technical work to make sure that everything went smoothly. And he was also juggling many questions. He's been WhatsApping me, or we've been talking about WhatsApp about the many questions. So, and thank you for everyone who sent in questions. That's been great. And last and certainly not least, a huge thank you to all of you for attending this webinar. It was the first one, as we said, that we've organized. We were very excited to have you participate. And thank you so much for all you do for Amnesty International and our human rights work. We are very grateful to all of you. So thanks very much, everybody. I hope you have a good evening, and the panelists can all unmute if they want and say goodbye. And it's been great to be part of this. Thank you.
Thank you, Rosemary.
Thanks, Rosemary.
Thanks,
Thanks,
everyone.
Thanks, Diem.
Bye. It was nice
Thank
meeting
you.
everyone.
Thank you, everybody.
Bye.
Take care.
Bye.
Bye.